One of four Jeffrey Epstein survivors who testified at Ghislaine Maxwell's trial has now warned federal judges that Trump's Department of Justice may be looking for a backdoor to avoid the congressionally mandated release of the Epstein files. Through her attorney, Sigrid McCauley, who has represented hundreds of Epstein survivors, she wrote a letter that was first reported on All Rise News. And I'm going to break it down today here on Legal AF. Take a moment to hit subscribe to check out my firsthand reporting. This was a letter that was filed in federal court in cases you might remember. It wasn't too long ago when Trump's DOJ sought to unseal grand jury records in three different courts, two in the Southern District of New York before different judges, and one in the Southern District of Florida. They lost every case. And what the judges always said was, this isn't real transparency. These grand jury records contain very little information. It was essentially an FBI agent summarizing already public allegations against Jeffrey Epstein and Ghislaine Maxwell. And two of the judges called it a diversion. They said to the government that if you want real transparency, you can release these files at any time. Now, in the wake of the passage of the Epstein Files Transparency Act, the government is trying again, saying the law has changed. Now we can try to unseal these grand jury records that won't actually teach us much new about the Epstein files. And the judges in those cases, U.S. District Judges Richard Berman and Paul Engelmeyer, asked the victims for their response. This is a letter, two-page letter, from Annie Farmer, one of four women who testified at Ghislaine Maxwell's trial against Ghislaine Maxwell. And she looks at the government's request with a very wary eye. She wants the grand jury records unsealed, but she has this sneaking suspicion that Trump's DOJ is doing this so that if the court says no, they'll use it potentially as what she calls a backdoor attempt to continue the cover-up. Here's the letter. Quote, Epstein's victims have been denied justice for far too long by multiple government administrations of both parties. Even now, the government has failed to investigate anyone other than Epstein himself and one of his accomplices, Ghislaine Maxwell. And there is no indication that the Department of Justice or any of its offices is taking action against other critical inner circle Epstein accomplices, despite congressional investigations and public reporting concerning his sex trafficking ring's financial infrastructure. Only transparency is likely to lead to justice, and for this reason, the victims fought tirelessly to achieve the Transparency Act's passage. Nothing in these proceedings should stand in the way of their victory or provide a backdoor avenue to continue to cover up history's most notorious sex trafficking operation, end quote. I'm going to stop right there. So they're saying right off the bat that the survivors of Jeffrey Epstein's abuse have been fighting to get to the point where a nearly unanimous Congress passed the Epstein Files Transparency Act. All that lobbying, all of those rallies in Washington that everyone had been seeing, that's what led to that point. And they're saying right there at the top of that letter by Annie Farmer and her attorney, Sigrid McCauley, who represents hundreds of survivors, they're saying that they believe that this fight, this grand jury fight that I've been following, that this might be the excuse, the backdoor avenue that the Trump government will cling to continue to cover up history's most notorious sex trafficking operations. Now, how will they do that? They have said, according to this letter, that protective orders are in place that makes it difficult to release certain information. And the letter continues, quote, while Ms. Farmer remains hopeful that the instant motions reflect a bona fide desire by the government to provide greater transparency into Epstein's crimes, she is wary of the possibility that any denial of the motions may be used by others as a pretext or excuse for continuing to withhold crucial information concerning Epstein's crimes. Now, there's a footnote, and a very telling footnote at the end of that paragraph, where she talks about the public excuse. I'm going to read it in a moment, but that if judges say grand jury records are secret, and if they say, as they said last time, nothing in these orders can stop you from releasing investigative files that might contain new information, well, they might ignore that second part. Here's what the footnote says. The government styled its motions as ones to, in part, modify protective order, reinforces Ms. Farmer's concern that the government will continue to use the orders issued by the court as a public excuse to continue to withhold crucial information. Now, you might remember when all of this was getting started earlier in the year, in July, there was that infamous memo by the DOJ and the FBI saying this is basically the nothing to see here memo. We have reviewed a large amount of information. There is no cause to initiate a new investigation, that there is nothing worth releasing to the public. Now, this letter became public on the day that the House Oversight Democrats released all of those eerie photos from Jeffrey Epstein's island in the Virgin Islands, so Little St. James. And I'm going to put some of those photographs on the screen. There were the odd photographs of the dentist chair in a room full of masks. There were just really eerie images. Think about what we've seen since that letter came out. Think of the birthday book with the letter signed in Donald Trump's signature saying another beautiful secret. May every day be another beautiful secret. There's been some transparency. There has been some documents in the public interest. And you know what? The clock is ticking. The Epstein Files Transparency Act it mandates within 30 days that the files should be released. It doesn't mean that they need to withhold it for 30 days. They can release files at any time, but they have a 30-day deadline that expires in middle of December 19th. And there was another detail in that July memo that caught the attention of Annie Farmer and her attorney, and that was the scope of the review. 300 gigabytes of information. That's what the government sifted through. That's what the government said, nothing to see here, nothing worth releasing. Here's how Annie Farmer ends her letter. Quote, Ms. Farmer therefore respectfully requests that any decision as to the instant motions, by which she means the motions to unseal the grand jury minutes, make abundantly clear that the court's ruling does not affect the Department of Justice's ability to release documents subject to the Transparency Act. For the avoidance of doubt, this would mean that nothing in the court's rulings affect the Department of Justice's ability to release other materials, including those contained in the, quote, more than 300 gigabytes of data and physical evidence in the government's possession. Respectfully submitted, Sigrid Macaulay, counsel for Annie Farmer. And there you have it. There's the 2-page letter expressing a serious concern that the government's at it again, that they're using what 2 federal judges so far have called a diversion, that is, the diversion of pursuing the release of grand jury materials that are not going to be that interesting, in order to obscure and cover up the files that are interesting, those 300 gigabytes of files, where the clock is ticking for that deadline of December 19th. And that's what they wrote to a federal judge and first reported on All Rise News. If you want to support All Rise News reporting on topics like these, visit www.allrisenews.com. That's www.allrisenews.com. If you become a subscriber, you support the work that it does to plunge through the public records, obtain the documents, report it first, and be on the ground for the court hearings that you care about. And to see other videos like these, take a moment right now to hit subscribe to Legal AF. Thank you for watching.
Can't get your fill of Legal AF? Me neither. That's why we formed the Legal AF Substack. Every time we mention something in a hot take, whether it's a court filing or a oral argument, come over to the Substack. You'll find the court filing and the oral argument there, including a daily roundup that I do called, wait for it, Morning AF. What else? All the other contributors from Legal AF are there as well. We got some new reporting. We got interviews. We got ad-free versions of the podcast and hot takes. Where? Legal AF on Substack. Come over now to free subscribe.